Siouxsie Wiles, Siouxsie Wiles, chemist, not a virologist or anything. Siouxsie Wiles rose to prominence as a great friend of the Prime Minister. She got a New Year's honour or something for it. And one of those people who was telling you to get the jab and telling you what the rules were about the COVID lockdown and everything else. Unfortunately, she broke a few of those rules. She cycled to the beach with her friend, had her picture taken there. It was all over social media. And it would be fair to say Siouxsie Wiles, not really her real name or a name she made up and gave herself, she became a little bit of a pin-up girl for the woke lefties and an object of derision for the anti-vaxxers. During that time, she was working at, I think, Auckland University and said she was in danger for her life or whatever. And they said maybe she should just calm down a bit and not mouth off so much. And that resulted in an employment court case. Now, I am not an employment court lawyer, thank God and his band of soldiers. But a judgment is out, and I'm told that Siouxsie Wiles won. Did she? To find out more about the case, someone who is an employment law specialist and indeed lawyer from the firm Lane Neve, Fiona McMillan, joins us on the line now. Fiona, thank you for lending us your expertise this morning, and thanks for joining us.
No problem at all. Good morning.
All right. Now, Fiona, you on the speakerphone or on the handset?
I'm just on my...
that's better.
Can you hear me okay?
Yeah, that's nice and clear now. So, Fiona, what was the claim or the case that Siouxsie Wiles took against her employer in the Employment Relations Authority in a nutshell?
Yeah, so as you've just touched on, Siouxsie Wiles provided commentary for media platforms during the pandemic. She started receiving some initially low-level harassment via email and social media from March 2020. That escalated. In mid-2021, the university advised Wiles and other academics that they should pull back from providing commentary around COVID-19.
Yeah.
Siouxsie Wiles subsequently raised a grievance. The university undertook an external safety audit in relation to staff safety and security. In October 2021, the university approached Siouxsie Wiles about her other speaking engagements and activities outside of work. And essentially they were telling her to stop that, and that these were outside activities that were not part of her role. So
they were prohibiting her from taking part in those activities, or saying we're not responsible for the consequences if you do, because there's quite a delineation, isn't there?
Yeah, correct. That's a part of it. And the other part of it as well is us saying, well, look, if you want us to protect you from a health and safety perspective, what do you actually want us to do about that? Which the employment court has criticised that approach.
Okay. Well, saying how can we help you? That seems a strange thing. So what was the judgment? What was the ruling in her grievance?
So essentially, to me, there are probably three important points from it. The first is the court has said that her academic freedom was not being suppressed in the circumstances.
So it's not a freedom of speech issue. She wasn't being muzzled or anything.
Well, I think they were trying and she wasn't. So I think on the facts, they're saying that her academic freedom wasn't being suppressed.
Yeah.
The second thing the court said is that the university's health and safety responses were insufficient and too slow. And this comes back to this point around, well, the university saying, well, look, what do you want us to do about it? The court held that actually wasn't good enough in the circumstances. They were saying Siouxsie Wiles and her colleagues, they weren't health and safety experts or PR response experts. It was up to the university to form a bit of a plan. And the third point around it is essentially that the work she was doing publicly, that was linked to her work, even though the university was asking her to stop.
Okay, so, well, okay, this, to be honest, Fiona, I'm confused. Oh, look, was there any compensation awarded? Was there any,
Yeah, so she was awarded general damages of $20,000, which Siouxsie Wiles has come out and said she feels vindicated by the decision, but I think probably commercially this is probably a pretty tough decision for both parties, right? I would suggest that both parties have spent more like hundreds of thousands as opposed to tens of thousands.
Believe me, I know how that is, Fiona. The other question is this precedent setting at all?
I think it's fascinating in the sense that an employer can say to an employee, hey, we want you to stop doing this. The employee keeps doing it, and then the employer is found liable.
Yeah, and that's what's kind of, to be honest, from a straight lay person's perspective, that seems crazy.
Yeah, look, I see why you think that. On the other hand, I guess we've got to remember, she wasn't doing a podcast about Love Island, right? It was something that was intrinsically linked to her role. But back to your original question.
No, well, it was intrinsically linked to her role, and it was causing problems. So, and she's not an expert in health and safety, but her employer, who we've now found, it was part of her employment or linked to her role, and the boss says stop doing that, which I would say they have the right to if it's linked to her job, because that's our first step in keeping you safe, is that you shut up. And she says, no, I'm not going to do that. I mean, how can the employer be at fault under those circumstances?
Well, Judge Holden disagrees with you and thinks that the university was liable for her health and safety in those circumstances.